Today, I'm going to be following up on a discussion I had with Sharon Bar-David in episode 7 of Fireway, where we talked about civility and incivility in the workplace and dealing with abrasive leaders. And I wanted to mention, as I was preparing for this, I actually looked back and found an article that I had written back in 2012 for Canadian HR Reporter. And the title was, "Managing is Not Bullying. Employees cannot characterize any negative interaction with a supervisor as bullying." So obviously, this is not a new thought that I've had, but it's probably even more relevant in 2018. What I'm finding these days is that we have more and more focus on bullying and harassment, which is really great. And I can say our firm has helped a lot of people who have found themselves in really horrific situations where they're being bullied, they're being harassed, and we've helped them either fix the situation by dealing with the management to get things remedied, or we've gotten them out of the situation and got them compensation for it and helped them find a new job. One way or the other, we've helped a lot of people. We've seen how serious this issue can be. The problem is that oftentimes what people call harassment really isn't.
I've been here for over 5 minutes, and the only nice thing you have said to me was nice resume, which I typed all night for this meeting with you. You've given me no guidance, no validation, no encouragement, no supervision. Is there an HR director somewhere?
HR director?
Yes, I need to speak to someone. I may have to take off today as a mental health day.
Some people have the impression that any negative interaction with their boss, with their supervisor, with HR is harassment. And one of the points that we often make is the entitlement to be free from harassment doesn't mean that you have an entitlement to be free from every negative interaction. And the law is very clear on this point. Employers are entitled to manage their employees. They're entitled to insist that they follow the workplace rules. They're entitled to impose discipline if they don't follow the rules. They are entitled to manage their performance. They're entitled to give negative performance reviews, even put workers on performance improvement plans where it's appropriate. If all of that is part of a campaign to harass someone or to force them to quit, that's harassment. But where the actions are warranted, it's perfectly appropriate. It's not harassment. And what I thought was interesting is in Ontario, we have Bill 132, which came into force in the fall of 2016 to deal with harassment and sexual harassment in the workplace. There were requirements for policies, for procedures to deal with harassment. They also had new definitions of what harassment and what sexual harassment is. And what I thought was very interesting is they also included an definition of what is not harassment. And what Bill 132 says is that reasonable action taken by an employer or supervisor relating to the management and direction of workplace or the workplace is not harassment. So the Ontario government even turned their minds to this and wanted to make it very clear. And this is the first point I want to make today is there's a very big difference between managing and harassing. That's the first thing to mention. And we often work with individuals either to help them, as I mentioned before, or to explain to them that what they are experiencing may be unpleasant, but it's not harassment. And in those cases, we've saved some people from making very serious mistakes because they wanted to go ahead and essentially quit and file a claim for harassment. And we've explained to them that they can always quit and they can always find a new job. But if they do so without finding a new job and try to file a claim, they're going to lose. And it's going to cost them a whole lot of money in addition to really interrupting their career. So that's the first point. It's a very big difference between managing and harassment or harassing. Second point I wanted to make, there is no law against being a jerk as a boss. And I made that point in my discussion with Sharon Bar-David in episode 7 of Fire Away. I'll make it again now because we see this a lot where we have people call us and they are complaining that they're being harassed. And of course, we'll sit down. Anybody that calls, we'll sit down with you. We'll talk it through. We'll try to get to the heart of the matter. But in many cases, it's, as Sharon and I discussed in episode 7, it's the boss doesn't say good morning to them every day. The boss is talking to them and looking at their phone at the same time, or interrupting them, or giving them negative feedback in perhaps not the most kind or respectful of ways. That may be very unpleasant. It might mean that you have an uncivil workplace and you may have an abrasive boss, and it's the type of thing that Sharon Bar-David can help you with, but it's not harassment. It doesn't give rise to a legal cause of action. And it's important that people understand that. When we work with employers, we will help them to put policies in place. And the policy should not just say, we don't tolerate harassment and we have a zero tolerance policy for harassment. What it has to do to begin with is explain what is harassment and, more importantly, what is not harassment. So getting back to Bill 132, make it very clear that harassment is not managing, even if it's negative interactions. but also make it very clear that if there is harassment as an employer, you make it clear where the employee should go to report it and what you will do, and that you will take every reasonable action to address it. And we work with employers day in and day out to deal with these things. From an employee perspective, if you think you're being harassed, contact HR, speak to your manager if they're not the harasser, or give us a call and we can talk to you. We can make sure that it really is harassment, and we can give you the guidance, give you a strategy on how to deal with the situation, including perhaps an exit strategy. If it's so bad and it is not going to be resolved, if you've gone to HR, they're clearly doing nothing about it, we'll help you develop an exit strategy as well and help you get compensation for what you've gone through. But either way, if you think that you need help, then you probably should be going to see a lawyer. And this thing I say every episode of Fire Away, which is that if you think you need an employment lawyer, you probably do. If you as an employee are experiencing these issues, if you're an employer and you see there is harassment, or you suspect there is, or you've had a complaint or heard rumblings, you need to deal with it. These issues rarely go away on their own. So if you think you need an employment lawyer, reach out to us. We'll be happy to help you. But otherwise, it's very important that people understand what is harassment and what is not, and that unfortunately, having a jerk as a boss doesn't mean you're being harassed. So that's my 2 cents worth, and you've got it here for free.